What up? What up? What up? Good morning, y'all. Second Court of Appeals, United States Circuit of Appeals for the Second Circuit. I'm sorry. Chief Judge Deborah Ann Livingston is
Hello,
residing.
ma'am.
I wanted to ask you if any of y'all wanted a drink machine, and there's a Yoda thing, and it's covered up.
Good morning. Good
But
morning.
my sister said it's her secret stash because it holds true Coke.
Hey, hold tight. hey, hey, Dana, you want something to drink?
Now good.
Um, Harold, you want something to drink? You want something to drink? You got to support the lady.
What up, y'all?
I can't drink sodas,
Me neither.
but I can get out. Yeah, you got to get. There you go. There you go.
That's
for you.
For real?
Yeah.
Thanks.
What's
See?
going on?
Now,
Let's
on that
share.
it says maintenance required, so that means I need a tune-up too, right?
Yes. Probably a tune-up or actually, what he'll reset your oil.
Is that what that is?
Yeah, let him know. He'll reset it.
Does your son want a drink?
No, he don't want it. Think so.
You're welcome.
Okay.
We here for it, y'all.
Mm-hmm.
We got 3 minutes until the countdown begins, till the judge come in.
You talking to me?
Yeah, I'm alive. He said, oh. Come on, man. Let's get these numbers up, y'all. Hey, TO307. Dewan. Good morning, everybody. Share. Tell everybody jump on. Come on, jump on. 15. Trying to see if I can get on. Man. $22. Good morning, good morning, good morning, Nisi. Love yourself. Hey. Let's see what the Second Circuit say today.
You ain't gonna be on there for the duration of the trial. That's a trial law. Fuck my phone up.
How?
No, you're gonna get a lot of calls on my phone. That's what I'm saying. That's a business phone. They're gonna call constantly,
Right.
so it's gonna keep interrupting you. Do it click it off or okay, if a call comes, just swipe it.
I got you.
Ignore it. I'll call everybody back later.
He's not going
Okay.
Come on, come on. Let's get these numbers up. Good morning, everybody. Kiva, good morning. Y'all know how this court thing go. We 1 minute to Dougie Fresh your own. Supposed to be 1 minute. You know how they get.
Girl.
United States Court of Appeals for the Second Circuit. Chief Judge Deborah Ann. What's her name? Judges of the United States Court of Appeals for the Second Circuit. Hear ye, hear ye, hear ye. All persons having business before this, a stated term of the United States Court of Appeals for the Second Circuit. Draw near, give your attention, and ye shall be heard. God save the United States of America and this honorable court.
Good morning, everyone. We have two argued cases on the calendar this morning, Yancey v. Robertson and the United States v. Kelly, and one motion, THEEBMOREACTOR v. Cuomo. And we have three cases on submission, Goldman v. Barrett, United States v. Thomas, and Hill v. City of New York.
Yes, Your Honor.
And Mr. Rupp. So we said 5 minutes. Would you like a minute of rebuttal?
Yes, Your Honor.
We don't usually do that, but as long as you stick to a minute, we'll do it this morning. And we're going to give you both 2 minutes to start, given the unusual format, and then we'll jump in with questions. Mr. Brody, if you're ready to proceed, I believe we're ready.
May it please the court, New York is curbing COVID spread. The district court's preliminary injunction would disrupt those efforts. Appellants therefore seek to stay the injunction pending appeal. Appellants will likely succeed on the merits. The state's distinction between large social gatherings and ordinary restaurant service is reviewed under the rational basis test, which the Supreme Court has described as a paradigm of judicial restraint. The district court misapplied the rational basis test by ruling that these particular weddings should be exempt from the state's 50-person gathering limit due to ad hoc case-specific factors. That was legal error. New York has a rational basis for distinguishing generally between large social gatherings and ordinary restaurant dining. Large social gatherings arrive and leave together. The COVID pandemic has been such super spreader events. That state's 50-person. New York also has a rational basis for adding the 50-person limit on top. You're not talking about a battle of the experts or a battle of evidence where they can prove somehow that this case deserves an exception. What we're dealing with is, does the state have a rational basis to impose a general rule that you can't have a social gathering over 50 people? And that's what the state has done. If the stay is denied, there's a high risk of irreparable harm. The 50-person limit on large social gatherings is a public health measure intended to meet an unprecedented threat. Commissioner Zucker stated that a stay is critically necessary. While nobody can predict with certainty that a particular event will cause a COVID cluster, Dr. Zucker explained that this is the type of event that acts as super spreader. And again, the 50-person limit applies on top of
Robert case is next, y'all. Just share.
The CDC
just keep sharing. Everybody share. Robert case is next.
Means more risk. That's page 151 of our addendum. And that was
the restaurant operation. Go ahead, Judge Walker.
Oh, this is just one quick question. I'm a little confused on the facts. The last I heard,
they got judges coming in.
What's happened to that one?
That wedding,
so the Court of Appeals,
a couple of hours after the administrative stay was issued, the plaintiffs filed a letter with the court saying they would reschedule their wedding.
Have they done so?
Not to my knowledge. Not to my. The letter was sort of sine die, indefinite rescheduling.
This is just maybe we ought to know that. I mean, so let's I'll ask them when they come up.
That's correct, and that's the reason why the balance of equities weighs against the plaintiffs. They can still marry, they can have a religious ceremony, they can hold their reception at Arrowhead. The state's simply trying to ensure that the wedding takes place in a safe manner, consistent with generally applicable rules to prevent viral spread. And they can have more than 50 guests if they use a video link or celebrate with other guests in a different place. They can retime their wedding as they have already. But compared to that, the public interest strongly favors this day.
Does the state regulation permit them to have a wedding with 49 people, in a large social gathering with singing and cheering in a restaurant that has a maximum capacity of 100?
It does. That's correct. That would meet both the 50% test and the 50-person limit.
There have been, of course, a large number of social gatherings in protests and demonstrations, which your editor has pointed out. Has there been any effort to find out if any spike has resulted from that?
The state is monitoring COVID clusters day by day. So there's a daily list that I've seen of COVID clusters. I don't know if any of those are linked to demonstrations, but it's important to note that there is no exception for demonstrations.
If you're saying that what you're doing is rational, then wouldn't you want to know whether the demonstrations are causing any clusters? What if they're not?
I'm saying I don't know whether the demonstrations are causing any clusters, but I'm sure the experts who are monitoring these clusters are tracking them back to the source. But the point is, I mean, demonstrations are not allowed in excess of the 50-person limit.
No Ewoks.
So, people have flouted the law in that case.
There's a truck full of Ewoks.
But that doesn't mean that you take away the general rule. Under rational basis standard, the question is there any conceivable rational basis for putting a limit on 50 on crowds? And the answer is yes, there is, because CDC says more people equals more risk. More people interacting, higher risk of COVID. And New York has now, from having been one of the world's worst hotspots, New York now leads the nation in fighting COVID. And that's because the state has exercised its police power, among other things, to limit large social gatherings. And a stay would allow New York to continue exercising those powers while this appeal is pending, to complete the orderly phased reopening that's now in process. And I want to stress orderly phased reopening, going all the way back to Williams against Lee Optical from 1955 in the Supreme Court. The state's allowed to address one industry, one problem at a time, and that's what we're doing here. The Department of Health is issuing separate guidance for separate industries, one by one, as we get them. And the state's perfectly allowed to do that under Williamson without violating equal protection.
Man, they pulled out Williamson on that.
Have there been any social gatherings in New York
that
have caused a spike? I know you cited one in Maine.
That Williamson case study has never been defeated.
Again, the origin in New York of COVID, the first super spreader event was a bat mitzvah in New Rochelle. So the answer to that's unqualified yes. That's where it began.
I remember that.
Baby.
Right, and it's rational for the state to say, okay, we're not going to have large social gatherings like that. And keep in mind, the 50-person limit is being adjusted. At first, it went to 0, and then it went to 10, and then it went to 25, and now 50. And the record shows the governor's office and the Department of Health are monitoring the incidence of COVID, and certainly there's every intent to lift the 50-person limit at some point, but we're not there yet. And that's what the governor's public health advisors are telling him. And under the rational basis standard, it's certainly rational to say, well, because there is this risk of a resurgence of COVID, which you're seeing in Florida, in California, in Georgia, in Texas, because there's this risk, we need to keep that limit in place at 50 at this moment. Now, plaintiffs may have an expert that feels differently, but the elected government of New York State is entitled to the benefit of the rational basis standard on this.
I don't know the configuration in Arrowhead, but a lot of wedding venues have rooms that are adjacent to one another, where you could actually divide up the crowd and put them in rooms, in compact rooms that have would meet the first 50-person limit. Would that be satisfactory? Suppose, even though the overall wedding party was 175, if they had 4 rooms that were
It's
adjacent
not
to
gonna
one
go
another.
right with
Um,
you.
and people
And then
adhered
you're
to
gonna drop
that
him
and
back
stayed in
here
those rooms.
before you go home, or
And they
he's
had
not coming
some
back here.
speaker
He's not
system,
coming back here.
that
Yeah.
kind of thing.
No.
Would that
He's
be
gonna be-
satisfactory?
Hang out with him.
Well,
He's
I
not coming back
think
here.
that would be up to the Department of Health because it gets very close to circumventing the 50-person limit where you say, okay, we're going to put a partition in this room,
Yeah,
and
we're not
people
coming back
can
here
walk in
because
and out of
I
the
gotta get
partition
that
and mingle
stuff
with
in the
each
house
other,
done.
but there's still
So
a
we're gonna
partition
stay
there,
at the
so
house and
technically
just
it's
try to
2
bang
rooms.
out all the
Now, I
little
will
stuff
say
that
this.
gotta get done.
The Arrowhead venue has 2 separate buildings,
That I'm
which
going
are
out.
physically separated from each other, and you could certainly have 50 people in each building of Arrowhead. Again, I'm not a health expert from the Department of Health,
Well,
but I'm
car,
sure the
y'all gotta
Department
get
of
back.
Health
How y'all
could
gonna
tell
get back?
Arrowhead whether it would be
drove
acceptable to put a
Tyrone's?
partition
Okay.
in or to use separate rooms.
So is,
But that's not what the plaintiffs are
I'm gonna go
asking
around
for.
the
They're
back
saying we want
and load up.
175 people.
And then we're gonna take that to storage.
Yeah.
Okay.
And then we're leaving.
Thank you, Mr. Brody. We'll hear
You
from
going
Mr.
back?
Rupp.
Yeah.
You want me to follow you back there?
No, you can go through the store.
Yes, good morning. You may have
Yeah.
please report. The state here bears a heavy
Yeah.
burden in demonstrating its entitlement to a stay.
Just to
The
come back
first
here
two
to
factors
bring
of the
Daryl back.
traditional standard for a stay are the most critical. And turning to the
That's what I
second
said.
factor, irreparable harm, the state defendants have made no effort to demonstrate that they themselves will suffer any irreparable harm if this single wedding goes forward. The only irreparable harm that the defendants claim is harm to the general public, not harm to themselves. But this argument conflates the irreparable harm factor, which is the second factor in the analysis, with the public interest factor, which is the fourth factor in the analysis. The fourth factor is not even reached if the state defendants cannot first demonstrate irreparable harm to themselves. None of the state defendants will suffer any harm, much less irreparable harm, if this single wedding dinner is allowed to go forward. Even if the state can claim the potential of harm to the general public as its own harm, the irreparable harm alleged must be not merely possible, but likely. The state alleges nothing more than holding a single wedding dinner might possibly lead to a super spreader event, but it does not demonstrate that such an outcome is likely. Indeed, the first of the 2 wedding dinners to take place at the Arrowhead venue on August 7th was not a super spreader event. The state has the proven ability through the State Liquor Authority, the State Department of Health, and the state police to monitor this wedding dinner closely to ensure that the venue and the guests adhere to all of the COVID-19 protocols, and the costs of doing so do not constitute irreparable harm to the state. Moreover, even in the highly unlikely event of a coronavirus outbreak, such an event would not cause irreparable harm to the defendants because, as Dr. Zucker points out in his declaration, the state already has counted at least 15 clusters of coronavirus victims that have been traced back to indoor dining. But the state did not find those outbreaks to be so irreparable or harmful that it reinstated the ban on indoor dining. I think here the state is misstating and misframing the issue. The issue is not whether the state has a rational basis in keeping a limit to 50 people for social gathering. The issue is whether, when the state has already granted 10,000 exceptions to that to every restaurant and bar in Western New York, in New York State, to serve more than up to 50% occupancy, whether it is at all rational to discriminate against folks who want to go to a wedding and sit down in the same restaurant in the same seats and be served the same meal as they would if they were just
It strikes me, though, it's problematic to frame it simply in terms of this particular wedding may not, how likely is it to be a super spreader event? Because by that, it seems you could undercut any reasonable and rational public health regulation, so long as you could say we're not the ones that will cause the grave harm. There's always an aggravated harm, and there will always be some need for exceptions, plans unfold. Why isn't the correct framing here just rational basis? Do they have a rational basis for distinguishing this large social gathering from the ordinary restaurant dining that could take place in this?
I just had a thought.
They do not, Judge, because this is what Judge Sotheby in the Northern District repeatedly asked the Attorney General's office to explain to him. The wedding couple here and the venue have submitted declarations to the court, many of them, indicating that they will abide by all of the restaurant protocols that are in place.
So they will wear masks to their table. They will remain at their table. The dance floors will pull up and they will not do dancing. They will not mingle at the bars. They will not go table to table. They just want to hold a dinner. And New York State has already said that this venue, which can seat 438 pre-COVID, can seat 219 people at a time for dinner without a risk to the public health. Yet, when these wedding couple, the bride and groom, want to hold a wedding for 175 and abide by all of the restaurant protocols that can be enforced by New York State, because they're very good at enforcing with the State Liquor Authority, the Department of Health, the State Police, the state says, no, you can't do that if you call it a wedding dinner. And that's where
Aren't there just differences between the use of a facility for restaurant dining and holding a social gathering in that same place? I mean, social gatherings are put up so people that know each other can mingle with each other, and it seems rational to me, the state's position, that there'll be more close interactions, even in for longer periods of time, even observing social distancing. Maybe everyone's wearing a mask, but in a restaurant dining, the different tables wouldn't even be talking to each other.
Well, Judge, the state trusts restaurant goers to wear their masks and not to mingle and go table to table when it allows them to dine. When we're talking about a constitutional right, equal protection of the laws, the state must engage in a practice that is the least intrusive. And what they've done here is they've said, well, all wedding goers cannot be trusted to do what restaurant goers do, which is wear their masks and abide by social distancing protocols, so we're going to ban them. What the Supreme Court has said is no, if you have alternative methodologies available to you to ensure compliance, such as enforcement, which the state is very good at doing, you cannot just ban a class of people and conclude that they are presumptively going to violate the law. And that's exactly what Judge Sotheby's seized upon when he said, you're essentially saying to this court that when these wedding goers in these venues say that they will abide by all the restaurant protocols, you trust them to do that if they're going to a dinner with 219 people. But you say that they're lawbreakers and you can't trust them when they're going to hold a wedding dinner with 175 people. He said that's not rational basis. The rational basis test is not toothless.
Well, the rational basis, as I understand it, just to make sure I'm not misunderstanding, but I understood rational basis review to be you look at the distinction that the regulation or the law is drawing, and the state is obligated to articulate a reasonable basis. It's not a fact-finding venture. Once they articulate their reasons, distinguish between and here it's social and it's restaurant dining. This particular social group happens to want to have their gathering in a restaurant. But the question is whether there's a reason to distinguish between a wedding party and restaurant dining. And it's not a fact-finding exercise. They just have to articulate a rational
it's the appeal.
And Judge,
am I misunderstanding that?
Well, Judge, first of all, I think you are, but first of all, the state did not do that. The Zucker affidavit that they rely on for the stay application is not part of the record on appeal. They did not put that before the court. The judge begged them to give him any rational basis for the distinction that they've drawn between 219 people dining, and turning over those tables over the course of the evening, maybe several hundred people, and a single wedding that books the venue for the entire evening, and they did not do so. So the rational basis test doesn't allow them to come up with some pretextual distinction that's not grounded in any proof or any evidence before the court to simply declare that to be the case. There's several records.
What are you talking about?
This Judge Walker. In a dining situation in a restaurant,
what are you talking about?
I take it that people come in, they can sit at their table, they take off their masks, they've got to eat and drink.
Oh no, because we're gonna revisit that. But as soon as it's finished, what?
And then they put on the mask
You like,
and
no,
they're
don't
dining the table. That's the way people work at restaurants. They would wear the mask to the table, wear the mask away from the table. Now, in a wedding situation, it seems to me, and this is, I think what Chief Judge Livingston may have been driving at, when people are mingling,
So the sofa.
can you expect them to get up from the table, put on their mask, go over and talk to somebody, and then take off their mask when they come back to the table? People are moving around all the time. They're taking their mask off, putting it on, and so forth. There might be a time, of course, when that does not occur. They're not wearing their mask. And also, the other problem is that the wedding is for hours of this. It's not like people just coming into a restaurant wearing masks, going to their side table and then putting on the mask when they leave and leaving. these people are going to be together. They're going to go and mingle, and
we put it on the floor yesterday.
Just
I had 4
common
people
sense
come
that
in
they're
and
not
look
going to
at it
always
and say,
have
"I
their
like
masks on
And they got on
because they're going to forget about it. By the way, they're probably serving liquor at this wedding, so the forgetfulness may magnify. I think that you can find the difference here between this and restaurants. I believe.
Hold on.
Well, Judge,
So somebody cloned
at regular
a page of me saying that?
And the answer is
That's not good, man.
class here,
That's not good. That's not me right there.
Plaintiffs in this case and the venue.
I don't play stuff like that. Stop playing with me, bro.
Every single one of the restaurant dining protocols. So we're talking about a venue that through the week, Monday, Tuesday, Wednesday, Thursday, Friday, can seat 219 people safely, according to New York. Trust them to wear their masks and abide by all of the things that you just indicated they would do, and they can turn over.
Look at the bed frame back there. You can't see it.
Class. Now, it's the same venue. These people want to hold a wedding dinner. They want to book the venue for the entire night. They want to have a similar dinner served by at the same table, socially distanced at the same location, served by the same wait staff. They simply want to have a wedding dinner. Will there be a head table with the bride and groom? Yes, but otherwise they're seated for dinner. They're not mingling. They're not getting up.
Are
They're
you
not
good
dancing.
getting out?
The state has every available option to enforce that, just as they enforce it with bars and restaurants across the state. So this is when the state says, well, we assume that you are going to break the law and do other things. The Supreme Court has said you cannot do that when you're talking about depriving people of equal protection.
I don't play that shit, man. You making pages, you making fake pages. I don't play that dumb shit.
All evening, as most weddings do.
I don't know if I know the answer to how much. For the sake of the question, that it would
These
be
people
several
just won't
hours.
quit.
But, compare that to a restaurant that can seat people at 5, 7, and 9
I'm glad I
o'clock.
seen
You have
that.
people coming in, going out, turning over those tables, mingling, waiting for a seat.
Yes, no, I understand. Can I just return to what Judge Walker was asking of your adversary? The wedding was supposed to take place on August 22nd, and obviously didn't. Do your clients have a plan as to when they're now intending to get married?
Well, yes,
Very
I
childish.
spoke to them yesterday
Fully
in
grown-ass
anticipation
people.
of a question like that, and
Bunch
they
of
told me
bitches.
that they are essentially waiting for this court to rule on the injunction to see whether they will be allowed to reschedule their wedding. As you might imagine, the Arrowhead venue, just like wedding venues all across the state, are hurting for business, and there's lots of capacity. So the venue and the couple would be overjoyed to be able to reschedule their wedding in the near term and hold it this fall.
Well, a stay wouldn't accomplish the problem. What you need is an affirmative by the Court of Appeals of the preliminary injunction, right? So you need to get the merits heard. The merits.
Well, Judge, actually, we're in the position of
So
having
what?
won the injunction preventing the state from enforcing the 50-person limit against the restaurant when it's serving a wedding dinner as opposed to a regular dinner. So it's the state that needs.
You're right. But the merits will ultimately, the decision on the merits will ultimately
for hip
determine
surgery,
when your clients will have the wedding right.
Until you
Okay.
You gotta start
Well,
walking.
Judge, if the stay is not entered, I believe that my clients lawfully can schedule and hold their wedding because the injunction would prevent the state from enforcing the 50-person gathering limit. It would not prevent the state from enforcing, as I'm sure it would, all of the social distancing protocols and all of the other COVID-19 rules applicable to restaurants.
But it sounds like if we were to deem this, if we were not to go your way, to expedite consideration, that they might be able to plan their wedding at some later point if they were to hear it.
Well, Your Honor, they probably could, but the question before the court, they were scheduled on August 22nd, and Judge Chin issued the interim stay pending the outcome of this oral argument. I mean, we are talking about a deprivation of constitutional rights. They do have irreparable harm that they demonstrated. There's a presumption of irreparable harm when constitutional rights are invoked. So I don't think the standard for the stay, which is a very heavy burden for the state to win on this matter, just involves saying, well, it's not a great inconvenience to them to have their constitutional rights violated. So I think they should be allowed, if the stay is not entered, and I don't think it should be, because I think the state has failed utterly to demonstrate a likelihood of success on the merits, and it's made no effort to demonstrate irreparable harm. If the court were to look at the submission by the state, there is absolutely no effort made to satisfy probably the most significant wrong in the stay analysis, which is irreparable harm. The state simply says, people might have a coronavirus outbreak or a cluster, but the standard is that they have to demonstrate irreparable harm to them, and they haven't even attempted to do so. And on behalf of the people,
this is not a particularly complicated case in terms of the law and the facts. It seems to me an expedited appeal you could possibly this could be decided within a month or 5 weeks.
Judge, I don't think the state has asked for an expedited appeal here. They seem content to proceed down the normal pathway, and we are in the position of the prevailing party. So we would not ask for an expedited appeal because we're trying to fight the stay. And
Yep. Thank you, Mr. Rupp.
Thank you.
Mr. Brody, you reserved 1 minute of rebuttal.
Thank you. Plaintiff's argument doesn't give proper weight to the 50-person limit. They say they'll abide by all protocols, but the crowd limit is one of the protocols. It's not expendable. With respect to the Zucker declaration, Zucker is before this court on this motion to stay. It's in our addendum. And anyway, the points were made previously in the Mazot Declaration, which is at pages 65 to 66 and 68 of our addendum. And we don't even need evidence under the rational basis standard. All the state has to do is show a conceivable rational basis, and we've done that. With respect to enforcement, we don't have resources to enforce against every social event, and we need these rules in place. With plaintiffs say that they're waiting for the court to rule on the injunction before they reschedule their wedding. That essentially negates irreparable harm. They admit that they can have a wedding at any time. And finally, with respect to predicting that this wedding will cause a COVID cluster, no one can predict with certainty that a particular event will cause a COVID cluster. But Dr. Zucker explains that this is the type of event that acts as a super spreader.
Let me ask this is Judge Jacobs. You're talking about the type of event, and your adversary is characterizing it as wedding. Would the 50-person limit apply as well to a fundraising dinner for the local congressman or a banquet in honor of the basketball coach?
Yes, Your Honor, it applies across the board, and there are not 10,000 exceptions, as counsel indicates. So it applies to banquets, it applies to weddings, it applies to all large social events. A person with no symptoms can spread COVID. While New York overall is at a 1% positive rate, tests from Erie County, where this venue is located, are coming back 3% positive. At a wedding with 175 people, that means 5 of them will have COVID without knowing it. They'll interact with the other guests who are going to take the virus home and spread it in their communities. That's how a pandemic expands. That's what the state is trying to prevent. Thank you.
Thank you, Mr. Brody. Thank you, Mr. Rupp. Very well argued on both sides, and we'll take the matter under advisement.
Thank you, Your Honor.
The first case on the calendar is Yancey v. County of Albany, and I understand we have 2 students from Seton Hall who will be arguing on behalf of the appellate this morning, and you've decided to divide time between you.
That's correct.
So we're ready to proceed. Because we're in this unusual format, you both are arguing for 4 minutes. We'll give you 2 minutes to start, and then we'll jump in with questions.
Okay, thank you. Good morning. May it please the court. My name is Sarah Ungeheyer on behalf of Michael Yancey. In a moment, my co-counsel will be addressing Yancey's 14th Amendment claim against the medical staff that was improperly dismissed sua sponte, as well as the subjective prong of his claim against Officer Robertson. I will first address the objective prong of the claim against Officer Robertson, the only genuine dispute between the parties. Whether Yancey had an objectively serious medical need in the form of difficulty breathing on the night of April 14th, or if, as defendants argue, his only condition was a mild skin rash. The primary issue before the court is whether there is a material dispute of fact in the record as to whether Yancey was suffering from more than just a skin rash, whether his allegations rose to the level of an objectively serious medical condition. Summary judgment here should not be upheld because abundant evidence before the court, including deposition testimony and a sworn verified complaint, showed that Yancey was suffering from a serious medical need, most notably difficulty breathing from an apparent severe allergic reaction. There was ample evidence for a reasonable juror to find that Yancey suffered from a serious medical condition. Yancey's sworn verified complaint, which should be treated as an affidavit for summary judgment purposes and should be considered in determining whether material issues of fact exist, states at 2 a.m. on April 14th, Yancey repeatedly called out to Robertson, "I can't breathe. Can you please take me down to medical? I've been having this issue with this outbreak. I have pus and blood coming out. I can't breathe. Can you please help me?" on page 106 of the appendix, and this is not in dispute. Further, Yancey's sworn verified complaint, as well as his depositions, include his testimony under oath at least 8 times that he couldn't breathe on the night of April 14th. He stated, "I can't breathe. I'm scared I'm going to die." When he finally received medical treatment 18 hours later, an ACCF doctor told Yancey, "You're breaking out because you were given the wrong medication. You're having a severe outbreak, and you're having some respiratory difficulties," on page 108 of the appendix.
What has to be a reasonable jury here, and correct me if I'm misunderstanding, but a reasonable jury has to be able to find that he was suffering from an objectively serious condition, a matter of urgency, reduced death or extreme pain, and so that he needed immediate medical attention. It wasn't enough to just put in a note for him to be seen next day. He's crediting his testimony when he says, "I can't breathe." Is that enough, even with the other evidence that we know he had an allergic reaction? I mean, sometimes people say, I can't breathe, I'm having trouble breathing, and they go to their doctor, and the doctor says, "This is not a big problem. Here, take this medicine." Sometimes it's a matter of more urgency. And there's no medical evidence here that says that evening he was suffering from severe respiratory distress. So help me understand, why is it enough to just take his articulation of the symptoms absent some medical expert in the record?
Yes, Your Honor, there are 2 answers to that question. The first being that, in fact, the record does support that he was suffering from a severe allergic reaction based on the fact that he was then taken off the medication, prescribed Benadryl and prednisone, and admitted to the infirmary. But more importantly, the issue is that he was not able to provide evidence of his severe need on the night in question for the exact reason that he's bringing this claim, which is the fact that he did not receive medical attention and was therefore not able to document the fact that he was suffering from difficulty breathing at the time that he requested care. So this makes it a lot more possible.
Counselor, I understand that part, but he'd been receiving his medicine for some time. I mean, it wasn't just that day, right? He'd been getting it for a period of time before that.
Yes, Your Honor.
And presumably, and he'd exhibited rashes and skin problems up to that point. This was the first time there was an "I can't breathe" component to this. And then later on, when he was examined, it turned out that they reinforced the rash. He wasn't having any respiratory problems at that time. So he might have had for some reason, he might have been panicked about not going to the medical facility because he really wanted to do it subjectively, and then made him have difficulty breathing. I don't know what it is, but it's not consistent. The respiratory problems are not consistent with the effects of the allergic effects of this particular medication. Am I correct on that?
Your Honor, on page 122 of the appendix, it states that the doctor had recorded that it was worsening over 2 weeks. So although there is some question as to what the exact allergic reaction was, at this point it cannot be discounted as summary judgment because the only evidence we have here is his sworn testimony that he could not breathe on the night of April 14th. And Robertson has put forth no evidence contradicting any of Yancey's statements. He wasn't seen until 18 hours later. So the fact that 18 hours after he requested care, he was still breathing, is not evidence that he was not suffering from a serious medical condition at 2 a.m.
There's also when he was seen 18 hours later or 16 hours later, he didn't at that time tell the medical staff, "Listen, I had this very severe, I couldn't breathe last night." Or at least that's not reflected in the medical records. Am I right about that?
Your Honor, I'm not. Yes, Your Honor. At the time that he was seen 18 hours later, it was not clear that he was suffering from any respiratory difficulties. However, he stated repeatedly in his deposition that he had, in fact, been suffering from this respiratory distress the night that he asked for care. But his symptoms here were consistent with
I guess my question
anaphylaxis.
was slightly different. Is there any indication in the medical records when he was seen in the infirmary 18 hours later, the indication in those records that he at that time reported, "Last night I suffered a very severe respiratory incident"?
No, Your Honor. The medical records, at least, are only the notations by the doctor that describe what he was suffering from at that time, 18 hours later. But the doctor informed him, "You're reacting to the wrong medication. You're having some respiratory difficulties," which he reported in his deposition. The fact that 18 hours later he did not report, "I'm having respiratory difficulties," however, does not make it impossible that on the night of April 14th he was in fact suffering from respiratory difficulties.
Judge Jacobs, he also reported that on that night he had open wounds covering his body and pus and blood, and that he looked like a person out of the living dead. Now, but 18 hours, 16 hours later, that doesn't seem to have been borne out. I mean, how did open wounds close in 16 hours? Why wouldn't it make sense for medical people or for a jury to conclude that everything that he was saying was exaggerated out of panic, which is perfectly sensible?
Your Honor, the jury could conclude that the issue about whether or not he had this specific pus and blood from certain parts of his body was or was not present. However, there is no evidence showing that he was not suffering from respiratory distress. And the record does indicate that he had a worsening rash, but that is not the material dispute of fact that would conclude whether or not he was in need of immediate care on the night of April 14th. And a rash...
Your point is that they didn't take him there it was 14 hours, I believe. I think Judge Livingston was correct. 2 a.m. But then the next morning, he's there, and the prison is operating under normal circumstances. There are guards nearby and so forth. And there's nothing in the record to indicate that he complained at that time when he woke up the next morning. He waited all day and then went to be checked. Is there anything in the record that shows that there was any complaint made between 2 a.m. and the time that he went to the doctor?
Your Honor, the record states only that 18 hours later at 6:15, Dr. Masaba then saw him. This is cited at 44-10 on page 122 of the record, and that was when they took him off of the medication that he had been prescribed, and at that point they prescribed him Benadryl. But it is not clear that he was seen before then. But it is also not clear that he wasn't...
I don't mean seen. There's no evidence in the record that he complained of respiratory problems to a corrections office in the morning, during the day, while he was waiting to be seen.
Yes,
right?
Your Honor. Yes, because as the issue before the court is whether Robertson recklessly disregarded this care. The record only states that there was one interaction between Robertson and Mr. Yancey, and then he saw no more of him the rest of the night. This does not indicate that Yancey didn't keep asking for help, which in his deposition he states that he did repeatedly continue to ask for help, but that he received no responses from Robertson. And Robertson is stating that no reasonable jury could find that Yancey was suffering from a severe medical need based only on Yancey's admission that he was not vomiting, convulsing, or unconscious. Robertson doesn't try to argue that Yancey's claim wouldn't be viable if the record showed he had difficulty breathing. He's only arguing that there's no evidence that he couldn't breathe, that no possible reasonable jury could find that he could not breathe on the night of April 14th. And that is simply not the truth. Yancey's observations of his own body may be appropriately considered by a finder of fact that assesses his credibility at trial, but they can't be disregarded on a motion for summary judgment. Robertson is in fact...
We'll hear from... Thank you. We'll hear from your co-counsel. Thank you very much.
Thank you.
Thank you, Your Honor. Good morning. Alexander Corson of the Seton Hall Center for Social Justice on behalf of Michael Yancey. Your Honor, as my co-counsel has just explained, Yancey did indeed have a serious medical need on the evening of April 14th, in that he was having severe breathing difficulties. And to add to the subjective prong, Robertson really only makes one argument, and that is that Yancey didn't have breathing difficulties and he simply had a rash, and therefore there was no serious medical need for Robertson to have recklessly disregard. But because at minimum there's a dispute of material fact as to Yancey's breathing difficulties, Robertson the argument as to the subjective problem and the basis for district court's granting summary judgment on the
No, it's not.
Must fail.
It's not, Steve. This is another case. It's not Rob case.
Your Honors, Yancey also brought a claim against the medical staff for prescribing him the medication despite clear documentation that he was allergic to it in his medical record. And the district court erred when it dismissed sua sponte, pre-service on defendants, because it applied the wrong standard. It applied the 8th Amendment deliberate indifference standard rather than the applicable 14th Amendment recklessness standard, as this court had held in Darnell 4 months before the dismissal. Now, in order for the district court's sua sponte dismissal to have been proper, they needed to find that there was no arguable basis for Yancey's claim against the medical staff, despite their charge under treatment to raise, construe his submissions charitably and to raise the strongest arguments they suggest. Now, setting aside the district court's application of the 8th Amendment standard, under the 14th Amendment standard, Yancey's claim was plainly violent. Under the 14th Amendment standard, Yancey would need to show, or at least claim, that prison doctors knew or should have known that giving him the medication would threaten his health and safety, and he alleges exactly that in his claim. He says that doctors knew of his allergy because it was clearly recorded in his record, and they prescribed it to him anyway, and then he went on to have a severe allergic reaction.
Now, there were not individual doctors named in the complaint, correct? I mean, you're saying now that you would have the opportunity to substitute Dr. Masaba for the corporate medical providers who were named?
Yes, Your Honor. That brings me to my final point. Assuming the court agrees with us that the sua sponte dismissal was inappropriate, that does raise the question of whether Yancey should be allowed to amend,
Grandma Jenna.
And whether, in order to substitute the individual doctor, and then, of course, whether that amendment can relate back under 15C. And in order for it to relate back under 15C, Yancey would have needed to have made a legal or factual mistake.
Let's get Robert out of here.
Unfortunately, this court's precedent
Let's get Robert home.
Soto versus Brooklyn Correctional Facilities is exactly on point. Soto said that naming an institutional defendant rather than the individual is exactly the type of mistake contemplated by a Rule 15C. And so we would ask on remand that Yancey be allowed to amend and substitute the individual medical staff members that were responsible for his severe allergic reaction, and that Yancey should be allowed to move that the amendment relates back. If there are no further questions.
And the theory is that these doctors, or Dr. Masaba in particular, should have known, acted recklessly and not knowing that he was allergic, and this multivitamin they prescribed caused all his problems.
I'm sorry, Your Honor's asking if the theory is that Dr. Masaba or whoever prescribed his treatment was reckless in doing so?
Yes.
Yes, that's the theory, Your Honor. So anyway, for these reasons, since Yancey submitted far more than an arguable basis, we would ask that this dismissal be reversed, and that he be allowed to amend to relate back. And if there are no further questions, we thank the court for your time.
Ms. Lady T. Dixie.
Thank you both very much. This was an assignment that Seton Hall took on pro bono on behalf of the court, and we thank you for your service. Well done.
Thank you.
We'll take the matter under advisement. The next case on the calendar is United States v. Kelly.
Here we go, y'all.
Good morning, Your Honor. May it please the Court. Thomas Farinello for Mr. Kelly, the defendant appellant on this appeal and the case below.
Yes,
Mr.
Mr.
Kelly has
Farinello,
moved
we'll also,
pre-trial.
I just wanted to just say, we'll also give you 2 minutes before we jump in. Sorry, didn't mean to interrupt.
Mr. Kelly has moved for pretrial release in light of the recent precedent resulting from the coronavirus pandemic, which unequivocally supports his temporary release in order to prepare for trial. The appeal is based on clear error because, among other things, the district court, after determining that a change in circumstances did not compel reconsideration of Mr. Kelly's bond conditions, failed to consider that Mr. Kelly must prepare for his imminent trial, which is a compelling reason under 18 U.S.C. Section 3142. It has been almost 6 months since Mr. Kelly has met with his attorney. While this issue is not unique to Mr. Kelly, during this time, his circumstances are unique and exceptional because of the undisputed fact he cannot read and write. The district court did not consider this undisputed fact and did not discuss or address Mr. Kelly's ability to prepare for trial and the impact of the COVID-19 pandemic in its last denial order of May 15th, other than writing that Mr. Kelly would have an adequate opportunity to prepare for his upcoming trial, which at this point seems difficult even if he is released, and impossible if he is not released, given the current climate. Additionally, Mr. Kelly has been the subject of an unprovoked attack while incarcerated at the FCC because of who he is, and it's clear that the Bureau of Prisons cannot adequately accommodate the need to keep him safe. And additionally, the imbalance that's created by Mr. Kelly not being able to meet with counsel and prepare with his limited ability to read and write violates his guaranteed right to a fair trial. The right to counsel and the purpose, the right to counsel and, I apologize, Your Honor. The right to counsel is a guaranteed right, Your Honor. And at this point, it is being denied to Mr. Kelly.
Is there a trial date scheduled at this point?
Your Honor, there has been 2 trial dates, and they've been, right now at this point, the last trial date has been converted to a status conference. However, jury selection has been adjourned twice.
Excuse me, where is he incarcerated at the moment?
Currently, he's incarcerated. Thank you for the question, Your Honor. Currently, he's incarcerated at MCC in Chicago because he's also facing charges in the Northern District of Illinois and the Cook County State Court.
Is he going to be tried there first?
No.
I believe he's going to be tried in the Eastern District first, Your Honor.
First.
Yes.
So he's waiting he's sitting in an Illinois detention center waiting for trial in the Eastern District. That's where things stand right now.
Yes.
And he's been there for about a year at this point.
Yeah.
It's over a year, Your Honor. He was arrested on July 11th of 2019.
And can you just tell us what your level of contact is with him? I mean, you described it briefly, but I'd like to hear it in more detail. How you're consulting with your client.
At this point, Your Honor, it is extremely difficult to consult with Mr. Kelly. Mr. Kelly has a number of lawyers, and they've had limited conversation. They are limited to 15-minute phone calls with him, and there's essentially, the protocol at this point is the prisons are not accepting visitors, and there's a very strict protocol with regard to prison calls, but they have to be scheduled, and Mr. Kelly is facing a number of charges that contain thousands of documents, and it's seemingly impossible to have any substantive conversation under the current restraints that are in place at this time.
Why isn't the solution here not to grant bail, but to make sure that the district court accommodates counsel's need to meet with him when he returns to the Eastern District. Perhaps schedules a conference and then makes rooms available next to the courtroom, that kind of thing, so that there can be conferences. It seems to me that this is sort of a trial management issue in a way, to allow counsel to prepare, rather than this sort of this blunderbuss approach of just releasing it. He faces very serious charges. There's lots of reasons not to release it. And if we didn't have coronavirus, I don't think you'd be here. But why not just leave it up to the district judge in the Eastern District when the time comes to make sure that he's has adequate time to meet with counsel?
Well, Your Honor, I appreciate the court's question. The reality is there are other defendants who have already been convicted of serious felonies and who have also been determined have been determined that they are a flight risk or a danger to the public, and they have been afforded the right to be released to prepare for trial. United States versus Avenatti, the court set up a very specific set of restrictions where the defendant's ability to communicate with the public is severely limited. He cannot have any outside communication. He cannot have any cell phone. He must be on monitoring. He cannot use the internet without him being in the presence of counsel. And there were accommodations made because in the United States versus Avenatti, he is facing a numerous amount of charges that entail the need and necessity to prepare for trial.
Well, the standard of review is not helpful to you, right? I mean, we reverse a district court for clear error based on a firm conclusion that they've made a mistake. And here, the district court, looking at the seriousness of the charges and factors about your client, came to a determination that he would be a risk of flight and a danger to the community. And this is a presumption case, and all those are factors that make your argument more difficult. In fact, the original detention order was not appealed. But now you're arguing, I think, both two things, and correct me if I'm misunderstanding. You're both saying that there's a compelling reason for him to be released now because of the need to prepare for trial, and that the court got it wrong on that original detention order. Do you want to address the second of those? What was wrong with the actual determination of the judge that this was an appropriate detention case?
Well, the court basis for determining risk of flight for Mr. Kelly and for the court's determination that he obstruction is based on speculation. And Mr. Kelly has had prior proceedings. He is always appeared in court. The court did not weigh the fact that Mr. Kelly has been a very cooperative defendant. As a matter of fact, when he was arrested in Chicago on the charges he was walking his dog, Mr. Kelly has never demonstrated that he intends on fleeing. And the other thing is that even if the court found there was convicted,
sometimes here, give me this thing. I don't even use it no more. Huh?
He has a history going back to 2008 trouble in Cook County. He was ultimately acquitted. And they found obstruction and intimidation of witnesses. Why is that a relevant concern?
Now, but Your Honor,
so they can ride through the HOA.
The question.
Yeah,
not
just push everything in the
now
middle.
Because he hasn't been found to have obstructed. He's been accused of that in the Northern District case. But at the end of the day, the evidence presented, there was no record of evidence that demonstrated that he was likely to commit obstruction, Your Honor. Again, the record is based on speculation, and the underlying the initial decision didn't consider that there are in fact conditions that can be, even if we can see the construction argument, there are underlying conditions that can be put in place by the Bureau of Prisons to monitor Mr. Kelly, to restrict his access to by way of telephone, cell phone, internet access, and use of the computer only in the presence of counsel, by which it would ameliorate that concern.
Bigger too.
That's a big boy.
We'll hear from the government.
Did you look at it?
And you reserve 2 minutes of rebuttal, Mr. Garnell.
It's a nice football team. Guess what?
May it please the court. Good morning. Maria Cruz Melendez, Assistant United States Attorney for the Eastern District of New York. I represent the United States, the Kelly in this matter. The appellant, Robert Kelly, is charged in the Eastern District of New York as the leader of a racketeering enterprise engaged in racketeering activities spanning 2 decades, involving bribery, kidnapping, sexual assault, sexual exploitation of minors, coercing and transporting girls and women to engage in illegal sexual activity and forced labor, as well as with multiple Mann Act violation charges. As Chief Judge Livingston pointed out, the grand jury's finding of probable cause that Kelly committed multiple offenses involving minor victims subject Kelly to the rebuttable presumption that no condition or combination of conditions will reasonably assure his appearance and the safety of the community.
I thought you was putting that in. That's why I was going on the front.
The defendant failed to rebut that presumption.
I would
And
get it out. I
notwithstanding
wouldn't
the
leave it out
defendant's
here.
claims, this determination is strongly supported by the record. It's not mere speculation. For example, as Judge Walker pointed out, there is a history of obstruction. A grand jury in the Northern District of Illinois found probable cause that Kelly engaged in a long-running conspiracy to obstruct justice in his 2008 trial, where he secured witnesses' silence and suborned perjury, bribes, blackmail, threats, and intimidation.
I just want to make sure.
In addition, based on the 2 pending federal indictments, there's also probable cause that Kelly committed at least 5 serious crimes while on bail awaiting his 2008 trial, namely kidnapping and Mann Act violations alleged as racketeering acts in the Eastern District of New York, as well as charges of obstruction and conspiracy to receive and receiving child pornography in the Northern District. And additionally, the government made multiple proffers regarding Kelly's long history of interfering with, intimidating, and threatening potential witnesses against him, including the potential witnesses and victims related to charges in the Eastern District of New York. And, as the district court found, Kelly poses a flight risk, given the serious charges he faces in multiple districts. In the Eastern District,
The argument that there is a compelling reason for being here, it's really impossible to prepare for this trial, given the circumstances of his incarceration in Illinois, potentially in Illinois, and the lack of access counsel have to them.
Your Honor, the BOP has restricted some access to counsel, but ultimately with regard to accommodations for the purposes of preparing for trial, as I believe Judge Walker pointed out, that really is a trial management issue for the district court. The BOP's limitation on attorney visitation is reasonable given the coronavirus pandemic. And given the fact that Mr. Kelly still has access to his attorneys via telephone calls, which, if scheduled, can be unmonitored. And in fact, the BOP has made clear that to the extent defense counsel wishes, they can schedule in-person appearances with their clients. If defense counsel...
I'm not sure I understand the dynamics of the fact that he's incarcerated in Illinois, and we're talking about a trial in the Eastern District that's scheduled to go first. And we would be issuing an order if the other side prevailed, presumably to the Bureau of Prisons that would affect his detention in Illinois. And I'm not sure why he would be in Illinois.
Allow me to...
Go ahead. Yeah, clarify this. When the trial...
Yes, Your Honor. When the defendant was arrested
The defendant was arrested initially on an arrest warrant issued in the Eastern District of New York, and then subsequently an arrest warrant issued in the Northern District of Illinois, almost simultaneously. He was arrested in Chicago, Illinois. So he was housed at the MDC Chicago. For at least one appearance, the defendant has been transferred to the MDC in New York, but in terms of consistency, it's been determined that he'd be housed at MDC Chicago. Now, when the trials have been scheduled, the Eastern District of New York trial, the most recent scheduling, was set to occur before the Northern District of Illinois trial. The original trial was scheduled in the Northern District of Illinois. They had the first date. Since that time, because of various logistical issues, there have been adjournments, and currently there is no trial date. However, it's likely that a trial date will be scheduled appropriately in the future at the next status conference. But yes, Judge.
Where will that trial be?
The trial for the Eastern District of New York will take place in Brooklyn.
Yes, but you said there's going to be one scheduled. Is the first trial going to be in the Eastern District, or is it going to be in Illinois?
It's unclear at this point because there is not a trial date scheduled in the Eastern District of New York, whether or not that will take place before the Northern District of Illinois trial. The district court...
So it's not clear now which trial is going to take place.
That's correct.
He might stay in Chicago for a week period and go through that entire proceeding before the trial.
There's a panel of judges.
That's correct. Or if trial proceeds first in the Eastern District of New York, the defendant would obviously be transferred to the Eastern District of New York for the purposes of trial, preparing for trial and being present at trial.
You said that there was a possibility of in-person appearance with your client while detained in Illinois. What are the conditions on that? Is that at the detention facility? You can meet in person with your client if you arrange it?
That's correct. Defense counsel can meet in person with their client if they arrange it with the Bureau of Prisons and the local facility. It'll be done on a case-by-case basis, but based on with the facility, it is my understanding that the BOP is doing everything that they possibly can in order to accommodate those requests. And again, I would point out, Your Honor, that given the fact that no trial is currently scheduled, and the fact that the defendant currently has access, albeit more limited access, that there has been no violation either of his Sixth Amendment right to access to counsel or any compelling reason at this time, Your Honor, for the purposes of releasing him, even temporarily, given the previous finding by the district court that he poses both a danger to the community and a risk of flight.
This is Judge Jacobs. Do I understand that he's been in prison for a year, and the only opportunity he's had to meet with counsel has been unmonitored phone calls by appointment for 15 minutes at a time?
No, Your Honor, I think it's a misstatement by defense counsel.
What if he had? What if he had? He's been in jail for a year. I mean, it's all very well to say, well, when the trial is scheduled, it'll be a trial scheduling matter to see whether he can see his lawyer. But he's been in prison for a year, and it's certainly remarkable that you know, right now and for the foreseeable future, all he'll be able to do is talk to his lawyer on the telephone for 15 minutes at a time by prearrangement.
I understand Your Honor's question. However, I would like to clarify that the pandemic has only been in place since March. Prior to that time, to the extent counsel wanted to discuss discovery and meet in person with his client, he was more than free to do so. And in fact, counsel for Kelly has done so. With regard to the question of whether or not there is a concern that there's no trial currently in place, I think the district court has made very clear that we're moving forward. And as the things return to normal, the district court is very much so looking to put a trial on the calendar. In fact, defense counsel has suggested November for the trial, and while the district court was not able, because of a scheduling issue, to schedule it for November, all of the parties are in discussions as to how quickly thereafter the trial would be able to happen. And I would note, to Your Honor, the fact that with respect to adjournment, the defendant has not objected to adjournment with regard to the Speedy Trial Act, and that they're in the interest of justice. In that regard, with regard to the charges, as I believe Judge Walker pointed out and Chief Judge Livingston, the charges are serious in this case. It's not unusual that there would be adjournments for the amount of time that it happened here in this case, even assuming the pandemic.
Well, they're serious, the charges, and you spent probably a full minute listing them, and they're quite formidable. Surely, that's an argument in favor of incarceration arrangements in which he can consult with his counsel and prepare for his defense the same way you and your team can prepare to prosecute.
That's correct, Your Honor, and I don't think it's anyone's position that the defendant isn't entitled to prepare for trial. I think the question is whether or not in the district court's May 15th order, whether or not the court erred in finding that at that time in May, when the trial was scheduled for September, that was not a compelling basis for the purpose of a release sentence, even temporarily, given the risk to be posed to the community and the risk of life.
When you say even temporarily, you mean even to for several hours on a given day in a monitored, secured place near the courthouse or in the courthouse?
No, Your Honor. I think 3142I is often envisioned for the purpose of, as you mentioned, a few hours in courtroom or multiple days in a row in order to be able to go through documents. However, the way defense counsel requested temporary release in this case was essentially bail in the defendant's apartment under certain conditions like electronic monitoring and or curfew. And the district court found reasonably that those types of conditions were completely and utterly that those types of conditions would not properly secure the defendant, given his history of interfering with witnesses and victims, and that even if the defendant was wearing, for example, an electronic bracelet, that he could either secure an unauthorized phone or have other individuals on his behalf contact victims and witnesses. And under those circumstances, the court found that even for the pendency of the coronavirus pandemic, that release was not appropriate in this case.
Thank you, Ms. Melendez.
That's bullshit.
The government asked that the court affirm the district court's order denying bail. Thank you for your time.
Your rebuttal.
Thank you, Your Honor. So let's first deal with the issue that which trial will take place. Mr. Kelly's trial we've already rescheduled jury selection twice. The Northern District of Illinois case has multiple defendants who have been released on bond, and so it's likely that trial is a little bit further out, but for motion practice and other reasons. So it's likely that the district case will be tried first. Additionally, there has been a bail application in the Northern District of Illinois that has been made in light of this court hearing this application. Now, with regard to trial, United States versus Stevens, which was decided during this time, has said unequivocally that the defendant meets the burden by demonstrating at least one compelling reason that necessitates his release under 3142I, and namely the obstacle the current public health crisis poses. The preparation of the defendant's defense constitutes a compelling reason under 3142 for release, and that was the case in which the defendant had originally been detained. With regard to the meetings in person, defense counsel should not have to be faced with the prospect that they may be contracting the potential virus, especially given the circumstances that in the Eastern District, in the MCC and the MCC, the guards were tested to have had coronavirus in greater numbers than the inmates. We would certainly be at risk in doing so. And then additionally,
Counselor,
yes.
This is Judge Walker. Trial has been put off. There's a lot of uncertainty. Let's assume there's a trial date picked in the Eastern District. It's not going to be until after November. So between now and then, you would be transferred from the Northern District of Illinois to the Eastern District of New York. And then there would be several months, presumably, before the trial. Now, why, under those circumstances, can't he then make an application, or what you on his behalf, to the district judge saying, we're not able to prepare the thousands of documents here. We can't. It's dangerous in the MDC, and why don't we?
Thank you, Red Sweet.
Make a room available, and we can meet for 3 days, pick the days, to take the documents there and go over them all with him, and so forth, with marshals present, arranging so the trial judge can arrange that his Sixth Amendment rights are protected in advance of the trial, and handle it that way. That seems to be a logical way to do it, rather than just, granting him bail, which would be extraordinary for a person of this sort, absent COVID. Why not just be able to manage it that way? And the district judge is going to accommodate it because he doesn't want a motion a Sixth Amendment motion argument made on appeal that he's denied the person the opportunity to prepare.
Well, Your Honor, thank you.
Go ahead.
Thank you for the question. The reality is that for almost more than half the time that he's been incarcerated, he's not been able to meet with counsel. The amount of work that has to be done, especially given the exceptional circumstances and the uniqueness in Mr. Kelly's case, in which he cannot read. There's an extraordinary amount of work that has to go into being completed. And as it was stated in U.S. BIDA, where the defendant released on bail is available 24 hours a day to assist in the trial preparation. This is the type of thing that is necessary for the amount for what Mr. Kelly has faced. There are other defendants who have already been convicted in the Southern District of New York who were granted bail, and they are being housed in very limited restrictions, where they have where the government is able to monitor, as well as the Bureau of Prisons are able to monitor the defendant. And it's not a circumstance that's unusual while the pandemic is ongoing. And the courts have ruled that release has no bearing on any other bail applications that may have resulted in detention. The fact remains that Mr. Kelly needs to prepare for trial in person, face to face with his lawyers, and to lock him away for 6 months without any contact with counsel, it belies his right to counsel and his constitutional guaranteed right. There is no way that
the trial date was set for next June. Still be making the same arguments? I mean, trial takes place when in the Eastern District of New York. That's the time to address all of this. He's sitting in Illinois, and who knows when he's going to come to the country. But there isn't even a trial date. So, it seems like there's an awful lot of moving parts here that need to be settled before a real decision of the magnitude that you're asking for could be possibly made.
Well, again, Your Honor, United States versus Avenatti. Mr. Avenatti was found guilty of multiple felonies, and the court allowed his temporary release for 90 days to prepare for trial, and the court continues to extend the release dates for Mr. Avenatti, and the fact that he is facing a trial in California and yet another trial in the Southern District of New York, and he is out. He is free to consult with his attorneys, and the court determined that it's because he has a right to prepare for trial. Mr. Kelly can be placed under extraordinary restrictions in Chicago, where we can at least go there and prepare with him if necessary, or in the vice versa. There can be a condition set up where Mr. Kelly is restricted from any outside access as if he were in the Bureau of Prisons, and it would really truly would be one less prisoner that the prisons have to worry about contracting this virus. I mean, it's in the public interest to ensure that Mr. Kelly gets a fair trial, and it's not deemed that he's locked away in the MCC. Again, he was just recently tapped because of who he is, and so the fact remains that the same result can happen. It just doesn't have to happen within the Bureau of Prisons, given the compelling circumstances of this pandemic. It's unconscionable.
Thank you, Mr. Farinella. Well, I have one other question. The government did proffer evidence of recent obstructive conduct in the prison. Just address just that point. The smuggling mail and engaging in unmonitored calls, and a letter in which a victim was threatened.
Is that question to me, Your Honor, or?
Yes,
Yes, that question
it was to you. Did you just, no, I did not to the government, just to you. It was in their papers. And this is in response to your point that he can be monitored if released on bail in order to prepare for trial. But the government's response to that is that there's recent evidence of obstructive behavior, smuggling mail and life while he's in the detention facility. Why doesn't that suggest that it may be difficult to monitor him in the way that you suggest in order to prepare for trial?
Thank you for the question, Your Honor. The reality is the government's proffer provides no information to bolster their support that Mr. Kelly needs to have. This is a supplemental filing in their motion for an anonymous and sequestered jury. There is no evidence connecting Mr. Kelly to these three individual actors and what they did. There's no evidence that corroborates the government's assertions. They're blanket assertions in an effort to try to tip the balance to ensure that Mr. Kelly stays exactly where he is. If in fact Mr. Kelly was actively involved with these three actors, then it would be clear that Mr. Kelly would be facing additional charges. There is no evidence to support the allegations in the government's proffer to their supplemental filing, Your Honor.
Thank you, Mr. Farinella. We'll take the matter under advisement. Thank you both. Well argued. That is the last
Thank you, Your Honor.
Thank you. And that's the last case on the calendar for argument today. So I will ask the deputy to adjourn court. Thank you all. Thank you all for your argument.
Court stands adjourned.
Thanks, B. You had one person call. Yeah. Well, there you have it. I guess we'll wait for the decision to come down, y'all. The decision should be in within like a week or two, anywhere between 7 and 14 days. So, right, where's the evidence? That part.
Yeah.
So I want to thank all of y'all for joining. I love my mods.
We're here.
I seen y'all doing a lot. Well,
Maybe just want the big light with the loops.
well, all the judges got to get together because it was 3 judges on the panel. The judges got to get together. They got to cooperate. They got to listen to the story again. They got to listen to what's going on, and then all 3 of them got to come with a verdict. Either 2 of the 3 got to be unanimous. I mean, 3 of the 3 you be unanimous. 2 out of the 3, you know. But if they come back as like a deadlock, that's why the 3rd judge is there, is either he can say yay or nay. So if he's, you know what I mean, there's no evidence, and I like the way Tom set that up. Somebody asked who was the lawyer. The lawyer was Tom Farinelli. Thomas Farinelli. Very good guy, very straight. The government has no evidence after all this time, no argument that's true. I kept telling y'all that. Even when they looked at the devices, it's nothing but the tour. So when you're looking at the tour, you like, well, damn, where's the evidence of him doing anything? There is none. One day people will listen when I talk. I told y'all I'm like E.F. Hutton of this shit. Hashtag nothing was found. That's right. And you think by them going into the second court of appeals, if not, if they had evidence going into the second court of appeals,
Yeah. You good, D? I'll see you later.
I let her know I'm going.
Okay.
Daryl, are you coming past the house?
Yeah, not today.
Okay.
I'll be there Sunday.
So, with permission, I was granted permission to bring y'all that recording. From my knowledge, I'm the only one that had the link. Y'all see I'm not near my computer, but I made it happen. I snatched my uncle's phone, asked him, can I borrow? He said, you go ahead. So, gotta do things, you gotta improvise, to make sure that everybody that's rocking with you know what's going on. So now, we got some things to do. We gotta spread this word. Just like they spread the word that he's this and he's this monster. So we gotta spread the word to depopulate that monster narrative. Like the lawyer said, if Rob was a part of this, additional charges would have been filed. Period. Robert will be home. I agree, Jess. No other channels is playing it. Oh wow, really? I wonder why. No other channels is playing it, but I'm the one that's the problem, right? Bet that. I'm not for Rob, right? Bet that. Like I say, if it was my cousin, my uncle, my homeboy, I'd do the same thing. Especially if I was around that person. I know that person's character, or if I was around at a certain point in time. You know what I'm saying? That's all it is. There's nothing but allegations and false narratives that's being pointed out there. And I'm gonna come back later. I'm just not gonna taint what happened this morning with what I'm gonna say later. Others were planning. Others like who was planning? Was oh, that's fine. But I thought they was gonna get in trouble if they played it though. Okay. I ain't pressed about it. It is what it is. Right. Right. I agree. Right. Ain't no eyes over here. It's all about we and us. It's all about we and us. It's us against the world, yeah. No negativity without it, right. So that's pretty much what's going on. Well, it shows that somebody powerful that have government ties just trying to keep him down, because if there's no, you don't even have evidence or nothing. That's sick. You keep me locked. You'll keep me locked up with no evidence. So what did I do? You have nothing but allegations. Maybe it's just me. I don't know. But look, I'll be back around like 1:30. And we're going to talk about some things that was addressed to me yesterday or last night. And since it was addressed to me, I'm going to address them back. But I'm a straight shooter. I'm not going to indirectly say nothing. I'm going to say what I got to say directly to who they are. I don't know. But y'all be blessed. I'm up out of here. Love y'all. I'll be back 1:30. All right. Peace.